Warning, this content may be disturbing to some audiences. Subscribe, if you dare.
Employment case. We got to the deposition of my client and all set up. The first question is, please state your name. The client looks at me and says, can we take a break? Hey everybody, welcome to ANECDOSED. People ask Reddit. Lawyers of Reddit, what is a detail that your client failed to bring up to you that completely lost you the case?
Number 1.
Opposing counsel, isn't it true you hit victim in the face with a brick? Client, no. Marcus hit him with a brick. I hit him in the back with a piece of wood.
Number 2.
He'd sent a photo of his wife's beaten face to his wife with a message saying something along the lines of this: do you want this to happen again? He came across very well in court up to that point, but his mask slipped when that came out.
Number 3.
Lawyer in the UK. I acted for a member of a famous criminal hunting group. My client was charged with various offenses relating to his vigilantism, most seriously, causing grievous bodily harm with intent. He wanted me to fight the case on a public interest defense point that is not available to him in statute or at common law, contrary to my advice. I followed his instructions as I'm bound to do. If the state won't punish criminals properly, then it's left to men like my client to take the law into their own hands, a horseshit argument for a whole host of reasons. His laptop was seized by police and submitted for forensic examination. He had a staggeringly huge database of pornography on it. He himself was a massive criminal. The laptop was seized as part of the initial investigation in relation to GBH, so it would have come out in any event. I guess if it was the case that his laptop was seized at some later point and he had already told me about what was on it before it was seized, I would have advised him to plead guilty in an attempt to mitigate the damage.
Number 4.
Minor traffic cases can be the worst for this, believe it or not, because they are short and simple and oftentimes the client isn't there, so if you get blindsided by something critical, there's often no chance to consult with them to turn things around. I had a simple speeding case, 70 miles per hour in a 55. No big deal. If she does a driving improvement course, the court will usually dismiss or reduce those, since her driving record wasn't bad. When I showed up for her, I found out that she had been driving 70 up an unplowed snow lane, to get around all the other cars traveling in the lane that had been plowed because they were driving too slow. I didn't know it was even possible to drive 70 on fresh snow. The officer stated he'd already cut her a break by not writing the ticket for reckless driving, and the judge politely agreed he didn't feel comfortable reducing it under those circumstances. When I called her up after court to confirm, she claimed she'd just forgotten to mention it. Now maybe I've lived too much of my life in the South, but that just boggles my mind as a detail you'd forget when hiring a lawyer for that incident. I would have told her in advance that hiring us was a waste of money, not to mention the hassle of taking an 8-hour class, and she should probably just go ahead and pay this one. I legitimately do that all the time during consults, give my honest assessment if the case is even worth doing, and so by omitting that detail she harmed herself for no reason. At least she took it well and didn't get defensive.
Number 5.
Client said his ex owed him a lot of money and that she was trying to get out of paying him back by getting a protective order against him. Seemed reasonable, so I took his case. At the hearing it came out that they were never a couple, that he was sending sex toys to her residence on a weekly basis, and that she never asked for the thousands of dollars he gave her over the years. Stripper. We lost, he got laughed out of court, and he learned a valuable lesson: tell your lawyer the good and the bad stuff before trial.
Number 6.
My dude in a custody battle where the opposing party claims he has a drinking problem and he denies it 1000%. Even after the real talk I have with him asking him to not hide shit from me and to be honest, we go into court and at cross-examination the opposing party provides video evidence of him finishing work, driving to an abandoned parking lot to drink a few tall boys and then going to pick up his kid from school. Every single access visit. He not only didn't tell me that, he forgot to mention that his ex's brother owns a private investigator firm. Effing idiot.
Number 7.
That he filmed his offenses for his YouTube channel. The cops didn't even know, a witness brought it up on day 3 of a trial. It was a nice quick change of plea that afternoon. A prosecutor has to give you all the evidence they have, that's because you have the right to know and answer the case against you. However, you can adduce new evidence during a trial if it has just come to light, etc. So for instance, if you find out that CCTV shows your client in England at the time of an offense that occurred in the US, there are certain tests that will determine if the new evidence is going to be admissible. During cross, however, you don't have a script of what the witness will say, only what they have said in the form of a police statement, usually, or the transcript of their evidence in chief, if you took notes or the court provided you with one quickly. Cross is perhaps the most dangerous part of criminal proceedings for a lawyer. You can be in a role and then an answer to just one question can ruin your whole case.
Number 8.
Case as a paralegal. Negligence case, client argued that a lack of street lights and a cyclist he couldn't see was responsible for him hitting a wire pole. Upon discovery, the first respondent's report indicated that they found the driver in the driver's seat, pants down, with porn playing on the phone. Wasn't difficult to figure out who was negligent at that point. From what I gathered from the document, he was knocked out and dispatched to get to the accident wasn't far. Basically, the airbag crashed, knocked him out, the phone took a tumble, and then the accident response showed up.
Number 9.
Employment case. We got to the deposition of my client and all set up. The first question is, please state your name. The client looks at me and says, can we take a break? We do, and she pulls me out in the hall to tell me she's lied to me about her identity. She's apparently a serial fraudster and has changed identities 7 times since the 90s. She apparently thought the other attorneys had somehow figured it out, and that's why they asked the question.
Number 10.
Guy in prison hired me to request a modification of his sentence because he was doing very well, completing a lot of optional programs, no rule violations, etc. He had his family come in and pay and everything to get started. I asked the family and the client if he had requested modification before, because the law said that for his conviction, he could only request modification twice for any one sentence, regardless of if they were granted or denied. Swore up and down he'd never filed before. You can see where this is going. After spending a few hours going over records and preparing documents, a copy of the CCS, the case record basically, finally arrived. He'd personally filed for modification 6 times since he was sentenced with handwritten pleadings that were all denied. So the one he hired me for was a waste of time and would never be considered at all. Several counts of burglary and armed robbery. The statute gives him 2 chances to request modification during his sentence, and he used those up and then some very early in his incarceration before he'd completed any programs. I'm talking about multiple requests in the first year. At that point he hadn't done anything to show he was rehabilitated, he just wanted the court to reconsider his sentence, which is not the point of the modification statute. It wasn't about the severity of the crime, it was a procedural issue. The limit keeps inmates from bombarding the court with constant requests like his, and allows the courts to just automatically reject excessive requests. So it had nothing to do with the merits, he had just screwed up by not consulting a lawyer before filing a bunch of requests. And then lying to me, causing me to do work on a matter that had no chance of accomplishing anything.
Number 11.
I'm a court-appointed attorney for qualifying individuals in family matters. Termination of parental rights case. Have been fighting to argue that a parent is stable, working lawfully, has a suitable apartment, doesn't need psychotropic meds anymore, ready to be a parent, etc. After a few months of negotiating with all the parties and the Department of Children, Court Services, we have a pre-trial to try and convince guardians. I meet with my client before the hearing to see if anything has changed. Nope, all good, let's get my kids. Great, that's not happening today, but let's try. We are going to court. My client, who is super hot-headed and quick to anger, gets riled up and goes off on the guardians. Screaming in open court. It doesn't end there, but reveals that she is no longer working, no longer in the apartment, doesn't want to have a relationship with guardians despite her kids loving them, and plans on moving out of state. Thinks they can live as a family off of state aid when she gets them back, and is 4 months pregnant. All in the matter of 15 seconds, I was too shocked to even react. Speechless. Not the image of stability and parental fitness I've been trying to paint since last July. Client was working really hard to get everything right, and legitimately had everything going for her prior to this hearing. I was not making false representations or trying to get a monster reinstated. This was a true bombshell, as I did my due diligence to make sure things were on the up and up and statutory requirements were met. This was a very atypical situation. Parents typically do a really good job working hard to meet their requirements.
Number 12.
Credit card theft/fraud case. When I was a young lawyer back in the late 80s, I was trying this guy on a CC case, and the witness was the department store clerk. Before video surveillance, the state relied heavily on witness identification. As she described the customer that was purchasing the very unique clothing her store sold, I asked her how she could be so sure it was my client. She looked at my client, who was wearing the most obnoxiously yellow shirt imaginable, and said, because not only does he completely match the description I just gave you, but he's wearing the exact same shirt I sold him. The jury convicted him, and I learned that day to better prepare my clients for trial. I worked without any supervision and tried to eke out a living as a private attorney doing appointed public defender work in that our circuit did not have a PD office at that time. So, in that my client was a rather inexperienced criminal and I was wet behind the ears. It was kinda like the blind leading the blind. I just didn't think to tell him to make sure he didn't wear any of the stolen goods to court. Now, 32 years later, I can look back and laugh. Then, I just wanted to crawl in a effing hole.
Number 13.
Years ago, I had a client charged with being drunk in public. It's a minor infraction, but he was on probation, so he needed to fight it. He told me he was very drunk that night, but had made it to the lobby of his brother's apartment, and was waiting for him to come down to get him upstairs. I take this information and run with it, bringing photos of the apartment complex and the bylaws to court. My goal was to prove that the lobby of the apartment was secured to guests and residents only, which would arguably take the drunkenness out of being in public. There is no formal discovery for minor infractions in my state. Since there isn't a real option for a plea deal on the minor charge and wanting to ambush the officer with my argument, I do not discuss the case with him and we go to trial. The wheels came off the wagon when the officer testified that he encountered my client at an apartment building on the other side of the city. He was outside at the call box, not even in the lobby of this different building, rambling and barely able to stand. I'm whispering to my client about this reversal and he slumps over and says something to the effect of, "Sorry, I meant to go to my brother's apartment." Maybe that's why he couldn't find me? And he sounded angry on that phone. Cross-examination was not fruitful. It was basically, "Officer, are you really sure it happened where you said it did and not at this other apartment building miles away?" Closing argument, that he wasn't that drunk, also didn't get us anywhere. In the end, there was a fast guilty finding, a minor fine, wasted ink and paper from printing useless exhibits, and light sanctions later on the probation violation. Make sure to share your personal story in the comments below and have the opportunity to be featured in a future video. Also, if you like these topics, don't forget to like, subscribe, and hit the notification button to continue seeing more content like this every day. See you next time.